Many states have their own inventories of historic or cultural resources similar to the National Register. Usually they're used as some kind of planning tool. For example, Arkansas has a register where, in consultation with the State Review Committee, it protects sites, districts, structures, buildings, areas, and objects significant to history, architecture, archaeology, or culture of the state. Arkansas lists things like tunnels, railroad structures. They have schoolhouses and courthouses. What you'll notice when looking through the Arkansas Register is that it's more relaxed on listing religious properties. Churches can be significant for their importance as churches. Take a look also at the legislation for the New Jersey State Register in the Division of Parks, Forestry, and Recreation in the Department of Environmental Protection. It lists areas, sites, structures, and objects that are significant for historical, archaeological, architectural, or cultural value as well. It provides for approval of the sites that can be publicly or privately owned. It requires the appropriate documentation to be included and maintained on the register. There's a historic plaque program, and the law also requires written notification to the owners. This state's register is also what limits the state funds that can be expended on the acquisition, preservation, restoration, or maintenance of historic sites unless they're included on the state register. There are also mini NEPAs, which, like the full-size NEPA, require the consideration of natural resources and historic resources. Remember that NEPA requires detailed environmental impact statements for major federal actions significantly affecting the quality of the human environment. It has to identify the environmental impact of the proposed action, any unavoidable adverse environmental effects, and alternatives to the proposed action. At the federal level, the law created a process to ensure agencies adequately considered the impact of their actions, but doesn't mandate substantive conclusions. Many state laws require the same or similar things to NEPA. Take a look at the law in Indiana, which sets out a state responsibility to preserve important historic, cultural, and natural aspects of national heritage and maintain, wherever possible, an environment that supports diversity and variety of individual choice. The law here is very similar to the federal law, using all practicable means to improve and coordinate state plans, functions, programs, and resources to fulfill the responsibilities of each generation as a trustee of the environment. Use the environment without degradation. These are the same kinds of responsibilities and policy ideas that were set out in NEPA. The law requires every recommendation or report on proposals that significantly affect the environment include a statement about the impacts, a description of those impacts that can't be mitigated, alternatives, short-term and long-term effects, irreversible effects, and so on. Indiana's Environmental Policy Act applies to major state government actions significantly affecting the environment. Some states have broadened the scope of their environmental policy acts to include local-level public projects as well. For example, take a look at the Washington State Department of Ecology website to see that their State Environmental Policy Act applies to decisions made by state and local agencies. This means state agencies, counties, cities, ports, and special districts like school and water districts. State environmental policy acts also differ in whether or not they specifically list historic resources as resources protected by environmental policy acts. In other words, there are state environmental policy acts that do not cover historic resources. Other laws, like the Connecticut Environmental Protection Act, explicitly include designated historic properties and allow legal recourse for the unreasonable destruction of structures and landmarks as defined by the National Register. Also, it's interesting that Connecticut's law applies to public and private entities and allows any person or entity to sue to prevent the destruction of historic resources. A limited number of states have adopted provisions similar to the Department of Transportation Act's Section 4F, which may apply to more types of historic resources than transportation projects. In other words, they've taken some of the language and provisions from the Transportation Act and applied them to preservation generally. Consider, for example, the New Mexico Historic Sites Preservation Act, where feasible and prudent comes up again. Look at the language in this preservation statute, which includes the feasible and prudent standard and the requirement to plan in a way that will minimize harm. In New Mexico, this doesn't just apply to transportation projects. Here, no public funds can be spent on projects that require the use of historic sites where there are feasible or prudent alternatives. But what do you notice here that might be missing? It covers expenditures, but what do we have at the federal level that we don't have here? It only applies to situations where there is an expenditure of public funds from the state, so that this does not apply to permitting processes or areas where there's a federal control over projects. There has to be some kind of expenditure. Although you haven't learned about the laws impacting archaeology yet, this information will be covered in the next module. Take note of the fact that there are also state archaeology regulations. About 2/3 of all states have some sort of antiquities laws designed to protect archaeological sites and materials. Some of these laws extend into geological and paleontological materials, underwater submerged areas, caves, and human burials as well. Generally speaking, state antiquities laws are similar to the Antiquities Act or the Archaeological Resources Protection Act. They have permit requirements for excavating on land owned and controlled by the states, and sometimes these laws extend onto lands owned and controlled by local governments as well. Some states even have regulations that guide investigations, prohibiting activities that could damage sites. These statutes frequently address who owns the materials that are found and have provisions for state archaeologists or specify SHPO responsibilities to administer antiquity statutes. There can be a state archaeologist that is separate from the SHPO's office and is in its own division. For example, Florida has a Bureau of Archaeological Research that's separate from the SHPO. Kentucky also has an Office of State Archaeology. There are many states that offer state tax credit programs as well. On this map, red indicates the state tax credit program, and yellow indicates where one has been proposed. This website takes you to the map, and the map takes you to the specific information about tax credits in the states that have them. It's a very helpful resource. If you're interested in preservation economics, you might want to take a good look at this site to see what it is that states are offering for tax credits, percentages, caps, and what types of properties credits are allowed. There are lots of weird and wonderful state historic preservation laws that go beyond the scope of specific preservation acts, environmental laws, tax laws, and register creation. For example, the Colorado Limited Gaming Act says that local building officials and local historic preservation commissions have to work together to ensure that neither historic preservation of existing buildings nor the safety of life are compromised in buildings where gaming occurs. California has a specific provision prohibiting the demolition or significant alteration of any structure damaged by natural disasters like earthquakes if the property is listed on the National Register or the California Register or in any local register of historic places unless they pose an imminent threat to the public or damage to the adjacent property. Go to the east, and instead of earthquakes, you have hurricanes and flooding from coastal waters. In Florida, structures listed on the National Register or the state inventory are excluded from the Coastal Zone Protection Act of 1985 and are exempt from minimum construction standards relating to natural disasters. Montana has a law that requires signs stating where the designated smoking areas are in state agency buildings of historical significance have to be aesthetically pleasing and fit the architectural style of the building. And Massachusetts has a special board to appeal the requirement that you have sprinklers. It authorizes the board to examine the architectural or historic significance of the building or structure in granting a waiver from an order of the fire department. So, There are a wide variety of state laws that apply to historic preservation. This is again why the lists of topics covered is so important, because you have to know what might be out there. Now you're going to take a few minutes to look into the state that you chose earlier on to see what kind of laws exist.